All right, let's dive into a really fascinating and honestly kind of scary part of the law. We're talking about implied admissions. It's this whole world where your reaction to something, or even your complete silence, can get turned around and used as evidence against you. So let's just put you in the hot seat for a second. Imagine someone points a finger right at you, makes a serious accusation to your face. Maybe you're shocked, maybe you're furious, maybe you're just totally confused, and you say, nothing. Does that silence automatically mean you're guilty? Well, that's the big question we're going to tackle today. So, how does the legal system even begin to deal with this? Well, there's a whole legal doctrine for this exact situation, and it's not really about the accusation itself. It's all about how you react to it. This is the principle behind implied admissions. Okay, so here's the most important thing to get your head around. The accusation itself, it's not evidence, it's just words somebody said. The real evidence, the thing a court actually looks at, is your reaction. Did you agree with it? Did you deny it? Did you just stand there looking shifty? All of that, it can be put right under the microscope. And hey, don't just take my word for it. There's this great quote from Lord Atkinson that just nails it. An accusation only becomes evidence against you if you accept it. And by doing so, you make it your own. And get this, that acceptance doesn't have to be you saying, yep, I did it. It can be your conduct, your actions, or even just your overall demeanor. But hang on, it's not a total free-for-all where any little twitch can be used against you. The system has these gatekeepers. There's a crucial two-step process in place, and the judge and the jury have very, very different jobs. Here's how that whole process breaks down. First, the accusation happens. Then, the judge steps in. The judge is like a bouncer at a club. They don't decide if you're a good person, they just decide if you're even allowed inside. They look at your reaction and decide if there's anything there for a jury to even talk about. If the judge says yes, then and only then it gets passed to the jury, and the jury has the final massive job of deciding what your reaction actually meant. Now here's where it gets really, really tricky. You're probably thinking, fine, I'll just deny everything. But it's not that simple. The way you deny something, your tone of voice, if you hesitate, your body language, all of it can make a jury think, I don't buy it. And in this wild legal twist, their disbelief can actually flip your denial into something that feels like an admission in their minds. So we've got the basic principle down, but what happens when you take these rules out of the textbook and throw them into the real world, where the stakes are incredibly high? Well, things get complicated, fast. This changes the whole game, doesn't it? Because suddenly, you're not on equal footing anymore. There's a serious power dynamic at play. So, does staying silent in a police interview room mean the same thing as staying silent when a friend accuses you of something? The law has really struggled with this one. And you know what? Even the top legal minds are split on this. You've got one camp, led by thinkers like Lord Diplock, who say, no way. The power imbalance is just too great. Your silence when a cop is accusing you just can't be used to imply guilt. But then you have others, like Lawton LJ, who argue that, well, context is king. You have to look at who is in that room. The fact that judges disagree so strongly just shows you how messy this area of law really is. Okay, let's crank up the pressure again. Let's say you've been arrested with somebody else, a co-accused. You've decided to stick to your right to remain silent, but they don't. They start giving a statement to the police, and that statement points the finger right at you. Back in the day, there was this really shady practice. Lord Goddard called it out. Basically, a police officer could go to the jury and say, well, I told the prisoner that his buddy John Smith said he was there. It was this sneaky backdoor way to poison the jury's mind with an accusation from someone they might never even see testify. It was a manipulative tactic, and thankfully, it's been shut down. So, the law evolved and created a much, much fairer system. Today, the procedure is super strict. The police have to literally hand you a written copy of the statement. And here's the crucial part. They can't say or do anything to try and get a reply out of you. If you do choose to say something, they have to give you the official caution first. Only after all those boxes are ticked can your reaction possibly be used as evidence. So we've looked at the rules, the debates, the procedures, but at the end of the day, all of this comes down to a fundamental human problem, the incredible danger of misinterpretation and the power of prejudice. This is the absolute heart of the issue. A judge can instruct a jury, okay, you have to ignore that statement you just heard. Only focus on the person's reaction. But can a person really do that?
Once you hear something damaging, it's almost impossible to scrub it from your brain and judge with a clean slate. You just can't unring that bell.
And this is the final and maybe most important safeguard. A judge has the ultimate power to act as a filter. If they look at the situation and believe that the damage done by the jury hearing the accusation is way worse than any value they'd get from analyzing the reaction, they can just exclude it completely, all to protect the fairness of the trial. So we kind of end up right back where we started, with a really tough question. This whole area of law is built on the idea that a jury can perform this incredibly difficult mental gymnastics to separate a statement from the reaction to it. But when you really think about human nature, can we honestly expect anyone to do that perfectly? It's a deep challenge, and it sits right at the very core of our justice system.